This is Legal Live with Eddie and Chuck Farah. They're talking the latest legal news and answering your questions. To call Legal Live and ask Eddie and Chuck a question, grab your phone and dial 855-765-1045. That's 855-765-1045.
That's right. Legal Live on News 104.5 WOKV, Jacksonville's News and Talk. Again, that phone number if you want to call in with your legal questions, 855-765-1045. Eddie and Chuck not here today. Anthony Evans filling in, who, what was it, 3 weeks ago now maybe?
About that, yeah, sounds about right.
Okay, so before we get into everything, we got some fun stuff to talk about, some legal stuff going on with college, NIL money. I know Disney Plus is getting a little bit of heat, and I guess you said you have a judge using some AI.
Yeah, to help decide, make a ruling on a case, to get an opinion.
Which is interesting, because maybe at least just 360 or eagle-eyed view of that, I was like, well, maybe it takes the human emotion out of it a little bit, but we can talk about that in a little bit. Before we get going, reintroduce yourself, what you do, obviously how you're involved with Eddie and Chuck and the Farahs, who obviously sponsor Legal Live here on News 104.5 WOKV.
Yes, so I'm Anthony Evans. I'm a personal injury attorney at Farah Farah, and I'm very grateful for the position that I have, the opportunity I have to work with that firm and great people and people that do so much for the local Jacksonville community. That was a big decision for me, going to that firm and starting to work there. Sure. So I like that a lot. It aligns with my views of helping people not, just in the courtroom, but also help build the community around you as well. And
so other than community involvement and all that, anything else bring you to Jacksonville? Have you been, how long have you been in Jacksonville, all that stuff?
Oh, boy. I moved to Jacksonville originally back in 2007.
Okay.
I was here from 2007 to 2013. Did a little bit of time in Orlando for law school. Then I came back around 2016. I was here for a few years, back to Orlando for a few years. And then my beautiful wife and I came here January of last year.
Okay.
I've been here ever since then.
Okay. And liking it, right?
Yeah, it's very interesting. The wife wanted a little bit of a change from Orlando, and I was trying to warn her. I was like, hey, listen, Jacksonville's a little bit different with the weather. Like, Orlando can be, we all know Orlando's hot, humid in the middle of the state, not much breeze, things like that. Here, I was like, I grew up in South Carolina. So I was telling her it's going to be a little. Your winters and fall is going to be a little bit different in Jacksonville, so get ready.
Yeah,
and she loves it.
Good. Yeah, there is definitely a little bit more seasons here than you get more south in the state. We do have a caller, so let's go right to the phone lines, which is so great for me because it's a topic we were just talking about off mic.
Can't wait.
Robert calling in here in Jax has an HOA question. Robert, thanks for calling in to Legal Live on News 104.5 WOKV. What's your question?
Thank you, sir. Good morning. Good afternoon. I live in a subdivision on a retention pond. I'm reading, for interest of time. I live in a subdivision on a retention pond, which is being overgrown with weeds and accumulations of trash at my end of the pond. In the past, the property manager for the HOA has coordinated pond maintenance with a pond maintenance company, but no maintenance has been performed in at least 3 months. I emailed the property manager on August 4th and included pictures of the condition of the pond. They responded they have forwarded my concerns and the pictures to the vendor. On August 21st, I requested an update from the HOA as nothing had been done. They replied they had reported this a few times and stated they requested to meet the vendor on property the coming Thursday. I left town for a week and returned to find nothing had been done. On August 29th, the HOA stated that they had reached out 3 times to the vendor and were told, quote, in a rude and dismissive way, unquote, that they were not willing to meet at the community and do a walkthrough. They requested permission the HOA requested permission for me to terminate the vendor's contract and hire another vendor. I asked them to refer this request to the membership as I had no unilateral authority to authorize this request.
Yeah.
I was curious why the vendor just refused service. I've been living here over 20 years. There's never been a problem with pond maintenance. To date, the pond remains a mess. Now, HOAs have power to compel homeowners to comply with their conditions and covenants and so forth. So my question is, what recourse does the membership have to compel action from the HOA as our agent within a reasonable time frame.
So I'm going to go out and just first put a caveat out there that I'm going to give you a general legal answer, as HOA law is not something that I specialize in. I've done it in the past, but not as I've been very far removed from it since now. But to answer your question, it's more along the same lines of you hire a roofer to do your roof, or you hire somebody personally to build your fence in the backyard, and they're not performing on a contract that you hired them to do specifically. That's the same kind of remedy situation that HOA would find themselves in with the company who's doing the pond maintenance and things like that. Now, I think it's a lot of small business owners and companies too will tell you these days it's hard to find good help.
Mm-hmm.
And I think that has a lot to do. That might, I'm speculating, but it might have a lot to do with it as well. I can't tell you why they didn't want to honor the contract or honor doing a good job, and doing a job to the satisfaction of a HOA, which a lot of the vendors that do work with HOAs, they try to keep it up and do a good job because that's a big lucrative contract that renews every year for them. So why would you not want to do it? And then if you do a good job for the HOA, that management company realizes it, and that management company calls you and says, hey, will you do jobs with this community and that community? So why a pond maintenance or whatever the company might be neglected it so bad, gave you all so much of a fuss, and just kind of walked away is beyond me. Maybe the company's dissolving. Maybe there's internal fighting. Maybe the company's splitting. I couldn't tell you, but it's the same kind of legal recourse you'd see if anybody, you hired somebody to perform a job, they didn't perform it the way that you wanted them to, and whatever remedies that contract allows, obviously giving them a chance to fix it. It's called mitigating damages. Give them a chance to fix it. Give them a chance to correct it, which it sounds like y'all did on multiple occasions. I mean, there may be something down the road in a breach of contract that this could be to where, you guys hire another company, they come do it, and you try to pass that cost along to the company that hasn't been helping you guys. But I mean, that's a lawsuit. Those are things like that. And if they're not willing to clean your pond and do a good job, I doubt they'll be, responsive to that as well.
Mm-hmm. Well, I think that we're on the track and as I said, she already suggested looking, to another vendor, and I'm all fine and good with that. But like I said, it's almost been 2 weeks, and as far as I'm concerned, nothing's been done. And granted, I haven't taken any more time to reach out to. I've been busy. I haven't been taking any more time to reach out to the vendor, to the HOA and the property manager to ask her, what the status is or whatever. But I guess that's where my question was going. Is there a specific, is there something concrete that I can do to kind of light a fire under them to say, hey, look, I don't care whether it's the old guy or the new guy or something. All I know is, my end of the pond is getting, I'm dying here.
Right.
So the only way, or the only thing I can give you in light of the question that you're asking is more to the fact of HOAs, sometimes government offices, and I say the DMV, but I've always had great experience with the Florida DMV. They're always quick. But in South Carolina, where I came from, it was always a pain. It took forever, never fast. And the HOA, if they do things correctly, it's not going to be super quick either unless there's a crazy little emergency going on. Because not only do they have to go get, in most HOA contracts, generally speaking, from what I've seen, and not a HOA attorney, they have to get multiple bids, multiple contractors, multiple people trying to do it. The board then sits there and presents it. It gets presented to the board. The board may even pass it out to a vote among the members of the community of which vendor they want to go with. And once that gets approved, that contract gets signed, and then they start going and doing that. But the thing is, too, is that also has to fall in line with what the HOA budgeted that year. If it didn't fall in line with that budget that year, then they got to come back and say, okay, well, community, we got to have a vote and talk about, do you want to take $1,000 out of the pool cleaning money to do this, to fix this now? So it's a lot of things revolving, and a lot of times HOAs aren't as solvent or lucrative and have money in the savings account like they're supposed to or they should. And so moving money around from different buckets to put elsewhere in the problems you might have, looking at new contracts, getting new vendors, and doing the process correctly, it's not an overnight thing. I highly doubt something you'd see changing within 30 days as well. You can only be the squeaky wheel. And what you're doing is fine. What you're doing is perfect. I mean, the HOA came to you. They said, hey, we got a vendor. Like, but you did a great, noble thing and saying, I can't make a unilateral decision for the community.
Yeah.
But you're turning the guns and you're turning the spotlight in the right direction to affect the change that you want. So you've done everything, in my book, you've done everything great.
Yeah. Well, except get
get your pond cut. Yeah.
Okay.
Robert.
Well, I mean, between you and me, I'm just going to get. I think I'm resolved here to take the weed whacker and put on a pair of boots and go out here and just cut down the weeds myself, spray some weed, some weed killer, and get a big fishing net and get this stuff out of the, get this trash out of the pond. But thank you for your time. That answers my question, and you have a good day.
Yes, sir.
Thanks, Robert. Thanks for calling in. It's Legal Live on News 104.5 WOKV, Jacksonville's News and Talk. If you've got a question, 855-765-1045. We will answer your calls after the break. This is Legal Live on News 104.5 WOKV, Jacksonville's News and Talk, sponsored by Farah and Farah, here to answer your legal questions for the next hour or half hour at this point. 855-765-1045. That's 855-765-1045. If you've got a legal question, Anthony Evans in today representing Farah and Farah. I did want to put a cap on the HOA question that we just got. I believe it was from Robert. I'm sure Robert's still listening. As we went to break,
yes,
we joked about, maybe I'll just go in there. I'll clean it myself. I did want to ask you, because I am curious, because I feel like I know where you're going with this. Would you suggest he just take matters into his own hands and clean up the weeds and the trash that he said is in that pond, since the HOA situation might take a while?
I need a little bit more information about the pond and the metes and bounds. Property law kind of description of who owns what and what does it say in the HOA covenant. Because the thing is, if it's common property, then I'd highly suggest against it.
Okay.
And for 1,000 different reasons and exceptions and rabbit holes, I can understand his frustration and something that's just so simple. Like, let me just roll up my sleeves and do it myself. Depending on what kind of property it's designated as and things like that, but the fact that HOA was doing it makes me think it was common property, because that's usually what they're supposed to do. Mm-hmm. I would kindly and respectfully advise against it, but again, I'd need more information. But just to go a little bit further with that, there was one time there was a community around here that a hurricane came through, and some trees or something fell down in their yard or close to what they thought was community property kind of thing. Lo and behold, you need to be sure, because I know in the neighborhood that we live in, I'm pretty sure the neighborhood owns a little thick patches of woods and forests in between the houses and sections of it. But sometimes you back up to nature preserves from the state that you don't realize, and this community did. And so they took some waste debris they had. And when I say waste, I'm not talking about littering. I'm talking about, some shrubs that got messed up, maybe some branches that fell, and they threw it in this area that seemed like a natural habitat. Well, there's trees down there too. It's not going to hurt. Boom. Next thing you know, they're having to deal with the state because they're throwing it on protected wetlands. And that's, forget it.
Not good.
No.
That's interesting that you bring that up. My neighborhood has some signs saying this, do not go past this moment. This becomes nature preserve. Don't go in here.
Oh,
Don't mess with it.
And the state will get theirs for sure. And it was a kerfuffle. We'll say that.
All right. So, Robert, if you're still listening, maybe, though we joked about it, don't do that, or call back with more information on the situation, and we can try to advise from there. Let's go to the phone lines again. We have another caller. Again, if you've got a legal question, 855-765-1045. That's 855-765-1045. We've got Glenn calling in from Baker County. Thanks for calling Legal Live on News 104.5 WOKV. What's your question?
Well, I'm dealing with, when I bought my home about 6 years ago, a home warranty company came with part of the contract, and I've maintained it over these 6 years. What I'm running into is in my heating and air, a year ago, we were having a problem with heat in the ear. When they warranty company sent somebody out, they said that that we were losing refrigeration, and they wanted to assume that the leak was happening somewhere in the walls of my house. And I happen to know a little bit about heating and air, and I said, no, I think it may be more the unit. Long story short, I got another company in. They said, yeah, your coils look rusted. I think it's in your coils where the leak. So back to the warranty company, they came in, pulled the coils, and the company that they hired pulled the coils, and sure enough, it was rusted, and that's where the leaks were. Now, the company they sent recommended replacement of the unit because the holes in the coil are very small. They said, we can repair, but there's no guarantee on this. Mm-hmm. So they said they told me and the company within a year, this will probably happen again. Well, now we're a year out, a year and a month, and sure enough, we started having an ear issues. And we called the warranty company. They sent somebody out. And when I looked up in the closet, there is mold now and mildew, and we've also experienced that in some of the rooms. Mm-hmm. So these leaks have caused different issues of the airflow and cause mold and mildew. The company, again, the warranty company, just wants to pull the coils and patch. Well, at this point, my wife and I, especially now dealing with mold and mildew and not knowing the level of mold, we don't want to go back there anymore.
Yeah.
I'm just wondering, do I have any legal recourse? Because the warranty company is saying, as long as it's fixable, we don't have to replace.
So let me couch this again by this is more of a contracts question. I do personal injury, so I'm just talking general contract law here that you'd find in Law School 101. Do you have legal recourse? I absolutely think so. Excuse me. Because the issue now has grown not just from the coils or the leak in the AC unit, it's also grown to the fact that you're experiencing or seeing mold, noticing mold in the position of where I guess the air handler or AC might be, air handler, I guess, and also throughout your house or in different places in your house. So it's gonna get a little tricky to where, are you sure? Like a lawyer has to prove that the leak in the AC was 100% or very close to the main cause of what caused that mold, and no other condition in your house caused that mold that's in the same closet where the unit might be, or and the same thing applies for wherever else you're finding mold in that house. How does a leaky coil cause mold 2 or 3 rooms away? That's what the lawyer has to prove and have to show. If he can do that, then yes, I do think you have a legal claim that you'd have to find a lawyer to take that case, take it up for you, and that kind of thing. This is a contracts case, has to do with the home warranty, and I mean they may be 100%. All we had to pay, all we had to do was replace the leaky coils, and if we did it within a reasonable amount of time, like a reasonable company would, they may not be on the hook for the mold.
Right.
But if they delayed, and if they gave you the runaround, or if the people who performed the service for the coils didn't do a great job and still replicated the same problem you had not long after that caused the mold, then yes, you do. So it's just there needs to be a little bit more homework. But the unfortunate thing is that everything costs money. And so, how much are you willing to throw down on an attorney to go after a home warranty company who they're going to have lawyers and that kind of thing versus maybe I just, see if I can't replace the whole unit and be done with it. Yeah. Maybe I can see if maybe I can hire a painter for less. And I'm being very economical and realistic with that answer. Yes, I'm a lawyer. Yes, I sue people. I help people in situations like these where there's been an injustice and you want justice. But unfortunately, at the same time, sometimes that justice has a cost associated with it. And if you do a cost-benefit analysis, can you handle it on your own for cheaper? Or, do you need to really just buckle up, get a lawyer, and have him go fight the big dog for you? And so that's more of a question you have to ask yourself.
Yeah, and that makes a lot of sense. I guess it just wears me out that these warranty companies can get away with this.
Yeah.
That's the part that bugs me, that they can do that. They can just continue to fix the little hole that doesn't really fix the problem.
Yeah, and that's
what they advertise is that they'll replace, but you don't get replacement off.
And that's the crazy thing, because no matter how good a company says they're going to do this or protect you with this, and it comes into my world with insurance, we're here to protect you. We're here to give you coverage. We're here to do things for you. Okay, well, I got $20,000 in medical bills. Oh, but that's not really $20,000. You weren't really that hurt. That wasn't related. I'm like, my goodness, like, are you there to help me, or are you there to just advertise something but sell me something different? Because anytime I have a problem, you fight me more than you help me. So are you really want to be, like a good neighbor, or are you trying to work against me? Like, are you the wolf in sheep's clothing? Like, what are you doing? Obviously, it looks like and appears like from a lot of the companies that deal with my industry and companies in general and what you're going through too. I'm going to say and promise you one thing, but it's going to look a lot different when I write it down in a contract.
Right. Well, thank you so much.
Sure.
You've given me some insight.
Thanks for calling, Glenn. We hope you can get everything figured out. And obviously, if you go down any of the paths and you want to share the story in upcoming weekends, feel free to call back. The number 855-765-1045. This is Legal Live, sponsored by Farah Farah on News 104.5 WOKV. We will answer your legal questions after the break. On News 104.5 WOKV, it is Jacksonville's News and Talk, sponsored by Farah Farah for the hour. Answering your legal questions, 855-765-1045 is the number to call if you have a question. We'll do our best to answer it. 855-765-1045. Anthony Evans in for Eddie and Chuck Farah today. And we've got some fun topics to talk about. Let's start with the college football stuff, the NIL, legal, I guess, drama, we'll call it. Just because, in the room here, objectively, there's two football games going on the TV. We got, Texas and Michigan going right now. So what's going on in the NIL world of college football?
So, yeah, a quick small update. There's obviously a case going around about a student-athlete settlement as it relates to the NIL and NCAA. Obviously, for those, most people know what NIL is, but what it allows people to do, or athletes to do, student athletes to do, is, you've heard about the rumors for years about how these colleges pay athletes to come to these schools. Well, now they're officially doing it. They're not having to do it behind the books and hide it. So we got to look at the veracity of that. So there's potentially a $2.7 billion settlement on the line. That's a big case that the judge is handling. However, the judge sent the case back to the attorneys to ask a few more questions for clarification, so she can make her decision. But one of the interesting things I got from the story is that the judge is suggesting to cap the NIL at $21 billion, I think, per school. So meaning the maximum amount a school could get from an NIL deal in any given year for the aggregate of all their athletes would be a $21 million cap. Obviously, plaintiffs are saying, no, we don't want a cap. Other side saying, yeah, that might be a bad idea. We'll look into it. But I think that it gets a little interesting, because then if it is capped and for whatever reasons, and you got to come back every few years and raise the cap. Like, what do you do?
It's like a professional sports league at that point.
Exactly. But you don't have like a commission of owners who sit around and have meetings throughout the year to, hey, do we want to raise the cap? Mm-hmm. Do we want to raise the minimum salary for the players? Like, what do you do? And then I don't think college football players have a union yet. So it's God, it's such a blend of professional sports and what we still want to consider amateur sports, mm-hmm. that is getting a little bit murky. And I thought it was really interesting with that $21 million cap that the judge was suggesting.
Well, and so I think it's one of those things where it's already opened. Pandora's box in this case is already open and shining a light on all these other now potential decisions or thoughts, mm-hmm. that are going to have to, happen. And if they don't reach a decision on this, like that won't help either, right? Like there has to be some kind of resolve here. Like you can't just not, like if you don't put a cap, then it's open season, which I guess is fine.
And see, so I'm a college football boy. I've always been all my life. Grew up in South Carolina. We don't really have a professional team. I mean, the Panthers are what they are, sure. But, everyone from the South knows what it's like to eat, live, and breathe SEC football. And one of the big reasons I loved watching, college football and college sports growing up, because to me, it was the last bastion of what true athletics and true sports really was. Because these kids aren't fighting for money. They're fighting for camaraderie. They're fighting for their team. And they're fighting for a lot of ideals that, in a lot of people's opinions, are far greater than money. And, that made that sport worth watching. Like, kids dug deep and things like that. I'm not saying they're not doing it now, but given time, we have baseball players a lot of the times who get criticism when they're playing. They didn't hustle and run to first base.
Sure.
Well, okay. Well, how much more money you want to put into this thing where kids aren't doing that anymore?
Well, and I guess my thought, too, is just back to the cap part of it. If before this was allowed in general, it was, quote unquote, potentially being done behind closed doors.
I think that's what Michigan's having. Correct me if I'm wrong, but isn't Michigan going through a similar ban because of?
There was a situation. Yeah, I don't know if they're still going through it, but I do know what you're talking about.
I think it's being alleged and they're looking into it. And things like that, but yeah.
But to that, if you put a cap, then what's to say they just do
the underhanded stuff again?
Right. Like you see the stuff until we get to the cap, and now it's the behind the books. But either way, let's get to a call before we get to break here. We got Linda on the line. I guess a legal question as it's coming through. So let's go to the line now. Linda, thanks for calling into Legal Live on News 104.5 WOKV. Thanks for calling. What's your question?
My question is, what are you allowed to put on the internet as long as it is absolutely true concerning a company that has not followed through with the contract?
Okay. So again, general legal question, or general legal answer as best as I generally legally can. Falling over my words here. Miss Linda.
Mm-hmm.
It seems we're talking about slander and libel. And it's been a hot topic a lot in our nation. There was a huge figure not long ago. And actually a lot of people suing for slander and libel in politics this last year. So the rule of slander and libel changes a little bit when you deal with public figures or political figures, but we don't have to go down that road because a company isn't one of those. However,
right.
The big thing to do with
it's a service company.
The big thing to do with slander and libel is that, from what I know and what I've read and what I've seen, again, general legal response is the truth will set you free. So as long as what you're saying is true, and it can be backed up factually, and it's true, okay, well, you can't get really upset about it, can you? Because when people have these lawsuits and things like that regarding slander and libel, like, person to person, that kind of thing, okay, well, here's the document that said, the message, the email from them that said, they said this. They told me this. I'm not telling a lie. This is exactly what it is. And so,
right.
and that very plain way of speaking, you should be fine.
Okay.
Just stick to the truth.
Okay, thank you. Thank you very kindly. Could you actually, I know that there's Elder Source or whatever, but is there any way you could recommend an attorney just to handle? I understand what you're saying about what it costs you to sue someone or take someone to court or whatever. Are you going to be out more money? I do understand that very well. But is there any organization? I am 79 years old, and I am an educated person, and I don't know. I guess my age group has not dealt with a lot of scammers, but actually the company I'm talking about is well advertised and, is a lucrative business. And
yes, ma'am.
I made the mistake of paying the full price without the job being completed, so I learned a rough lesson there.
Yes, ma'am.
But I'm not having any luck with phone calls in getting them, and I do have the receipt and what was on the email, the contract for what they were going to do.
So to answer your question, there is a service out there for you and a service that can help you. And, for at least give you better legal advice on what your remedies may be. And that's one thing you can do is the Jacksonville Bar Association. And they have some really great attorneys there who charge a lot of money in their private time, but then they devote their time to help the Jacksonville Bar Association. And they charge about $50 an hour. So they'll sit down and talk to you, give you great legal advice for $50 an hour. And their phone number is 904-399-4486. That's 904-399-4486.
4486. Okay. Thank you.
You're so welcome.
Thanks for calling in, Linda, and keep us updated with how everything goes. Check back in with us when you get a resolve. We appreciate you calling in. It is Legal Live on News 104.5 WOKV, Jacksonville's News and Talk, 855-765-1045. If you've got a legal question, we'll try to get you in before the end of the show. The last break coming up after these commercials. Legal Live on News 104.5 WOKV, Jacksonville's News and Talk, sponsored by Farah and Farah, answering your legal questions for the next 10 minutes or so. 855-765-1045 if you would like to call in. We do have some people on the line. Now, Robert is on the line, who called in earlier in the show. And if you're just tuning in, it was in regards to a pond and some mess that was not being addressed by the HOA. Robert, thanks for calling us back. Do you have a follow-up question and or statement?
No, I just wanted to know. It is. I heard you ask, was it community property? It is community property.
Nope.
Don't touch it?
I wouldn't.
Okay.
Okay.
So we joked about that as we went to break, but maybe don't actually do that.
Right. Okay. All right. I've composed another email and sent it to her to see if I can get an update. So I'll just keep on being the squeaky wheel.
Your HOA sounds, oh gosh, chill enough that they probably wouldn't care. However, doing those kind of things, community property and altering community property, a lot of HOAs will come back and bite you in the butt real hard for that.
Well, and let me ask this out of a hypothetical. If Robert, we wouldn't want this to happen, but say he's doing that and gets hurt.
There we go. There's personal injury.
Yeah.
So you're going to have a premises claim, and obviously Robert can sit here and say, well, I'm going to sue the HOA because they allowed this dangerous condition to happen, and I'm just trying to make it less dangerous for me because I have snakes coming in my backyard,
Sure.
et cetera, biting my cat, and I have to take my cat to the ER, those kind of things. It's all related. It's fine. But then the jury question comes also, and things, that new law they passed, so wonderful. Recently, the comparative fault now goes through the roof. So if a jury finds that Robert's judgment and what he did, he's 51% liable for it. Robert's responsible for all his injuries and everything associated with it.
Okay. And our producer is asking if would it be a possibility to ask the HOA for written permission to take care of it in that case?
Okay. That's a suggestion. Okay.
Maybe.
Thank you very much.
Because that written permission, does it absolve him of liability?
Okay. Yeah.
And I hate answering a maybe with a maybe and not giving a definite answer, but it is all in the language house because we're doing contracts.
Yeah.
And everything is so important about the words written down. It makes a huge difference. I know we haven't got to it, but the judge talking about using AI, he goes deep into the reason he's using it to look for different variations of what people mean by a certain phrase.
Sure.
But that's exactly it. What does it really mean? What's it saying? And if they absolve liability, are they doing it the right way? And I know we haven't talked about the Disney case too, but then when you look at arbitration clauses, there was a case I fought having a case go to arbitration, and I learned through the law that we have here in the state of Florida, and hopefully I did it right. I guess I did because I won the motion. But that when you have an arbitration clause to force arbitration on a contract that you sign, it has to specifically state exactly what the condition is that will trigger the arbitration to be for. So, and I'm just rephrasing, I'll struggle to put that in a pretty box. the words matter.
Yeah.
So they really, really matter to what
stated.
the HOA giving you permission to do this and just everything in that contract. Those words matter.
All right. Well, Robert, good luck with everything. Circle back with us. Let us know how it goes if you have time in future shows, okay?
Thank you very much.
Thank you. Let's get to the last call here. We got Diane calling in from Crescent City. Thanks for calling Legal Live on News 104.5 WOKV. What's your question?
Yeah, thank you, by the way, very much. This bill, a recent question that I heard on the show, and that was about slander and libel. And I had just tuned in, so I'm not sure if I missed something, and I hope I'm not being redundant. But my understanding is that, yes, you could potentially lose in a suit for libel or slander if you are stating something as fact and it ultimately is not fact. But if you preface your communication with something that suggests it is your opinion, then that negates the ability of somebody to successfully sue you. So, for example, rather than say, hey, Bob was just arrested for tax fraud, you say, instead of that, say, my understanding is that Bob was arrested for tax fraud, or I heard that Bob was arrested for tax fraud. So to me, it seems that would negate the ability of a successful lawsuit, because you'd be saying, I'm suing you, saying that your understanding is not your understanding. So what are your thoughts on that?
For the most part, you're not wrong. However, you need to be very, very careful, because there are exceptions to that as well. Because the thing is when you're speaking like that, and my opinion is, my opinion that, we have people do that all the time. However, if your language is that inflammatory, that what your opinion is and what you're saying may be your opinion, and how you're saying it, how you're couching it, and things you're giving to support your opinion seems to be more factual, and that's how people are understanding it, then you really weren't saying what you thought was your opinion. You're actually trying to maybe spin things to more towards facts. So you can sit here and couch, just like when, somebody's sassy to you and things, maybe you want to be sassy back and say, well, in all due respect. And what comes after that's about to be very inflammatory. Like, oh gosh, hold on. So you're not wrong. But even when you do that, you still need to be very, very cautious as well. And again, there's different rules for political figures as well.
Okay, very good. Thank you so much. I really appreciate it.
Absolutely. Thank you.
Thanks, Diane. Thanks for calling. So we've got about 2-ish minutes or so, which doesn't give us a ton of time, but I really want to get into the Disney Plus stuff.
Fun.
Which I guess is a little bit of contract talk in a way.
That's something. So the interesting thing about the Disney Plus thing, when I heard it come around, and I mean, I'm sure tons of legal community would disagree with me. And the way I approach it, it's not even legally. It's just like, who in their right mind at Disney or any big corporation that you want to be family friendly and so accepting and loving and all these things, and we care about you and your experience, who in the world thought it'd be a great idea to go ahead and leach an arbitration clause that somebody signed or agreed to in a Disney Plus TV subscription to an injury that happened to a food allergy within a Disney park, or I think downtown Disney Springs, whatever it is now. And what's crazy is, when I look more into it, that Disney Plus thing he did, it was just a trial subscription. He never paid for it.
He never actually paid.
Which may make a difference. It may not, but the court's going to decide, the court's going to figure it out. But a lot of companies now are trying to sneak things in to where they're having, if you use any part of our service or affiliation whatsoever, our arbitration clause, and this ties you to everything else that might be. And I'm like, what in what world? I mean, that's when PR and legal need to have a talk, because that's insane. Like, if you want consumer goodwill in your image, I think that's the last thing you could have done to
do that.
Yeah.
Well, and obviously it backfired from all the press that happened.
And I mean, the courts go back and forth on this a lot. They're going back and forth on this a lot. But one of the interesting things that they said is that AT&T and DirecTV. So they said a long time ago, AT&T customers, when they sign up, AT&T, there's an arbitration clause within that. And I think it was, or maybe I'm getting it backwards, but DirecTV later bought them. And so when something happened with DirecTV later, they're saying, oh, you signed that clause with AT&T and they have arbitration there, so we'll compel you to arbitration now because we own them. Well, that was actually going through until one of the courts came through and said, no, it's so far out, so far attenuated from what the spirit of what's supposed to be. And that highlights a little bit more what I was talking about earlier about the arbitration and that motion to dismiss that I had. what they were trying to do was compel arbitration to something in the contract provided for it, but it didn't provide for negligence in that arbitration. And it provided for more things of dealing with property and things like that, but not necessarily the claim that we were coming for. And that was the reason that motion was successful. I could take it to 10 other judges in the state, and maybe I'm not successful. But at least that's how it was read at that time. And some of the courts here are saying in the same article that you need to be very specific what the arbitration clause is going to apply to.
Interesting. And that's a little more in-depth look at the Disney Plus subscription. If you don't know the full story, you can go to News 104.5 WOKV and read all about it. It was heavily covered in the morning show throughout the weeks. This is Legal Live on News 104.5 WOKV. Jacksonville's News and Talk. Thanks for hanging out with us. Anthony Evans filling in
Thank you.
for Eddie and Chuck Farah. We will be back next week.